It may be useful.
Useful.
It may be awesome.
Awesome.
But that doesn't mean you should hang it from your rearview mirror. Section 375 sub 30 of New York's Vehicle and Traffic Law prohibits hanging or mounting any object, except required or permitted equipment, if that object will obstruct or interfere with the view through the windshield or the rear window. Of course, any car is full of required or permitted equipment that arguably obstructs or interferes with the operator's view. Look at the rearview mirror itself. It's required equipment and allows the driver to see what's going on behind, but it actually obstructs the forward view to some extent. Required or permitted equipment also includes the headrest that can limit the rearview mirror's usefulness. The term permitted would apply to an E-ZPass reader or electronic toll collection tag, to give it its proper name. The law doesn't actually ban all objects that aren't required or permitted. It only forbids non-required and non-permitted objects that obstruct or interfere with the driver's view through the windshield. How do you decide what obstructs or interferes with the view through the windshield? That's a good question. And because there's no clear answer to be found within the four corners of Section 375 sub 30, at least one court has declared the statute unconstitutional. No court above the county level has said so, though. And the law, which has been on the books for many years, is routinely enforced. And such enforcement has been ratified routinely by appellate courts. What doesn't violate Section 375 sub 30? In at least one case, the prosecution failed to prove that an unnamed and undescribed object hanging from the rearview mirror obstructed or interfered with the driver's view. In another, an air freshener didn't obstruct the driver's view when it was hanging from the defendant's rearview mirror, was at dashboard level on a string measuring 1/10 of an inch wide. On the other hand, a Virginia case applying a statute similar to New York's involved a 4x6-inch blue tree air freshener hanging from the rearview mirror. The court described objects of this kind as a "stop me if you want to" sign. A New Jersey court found that a pair of miniature boxing gloves measuring 3.5 inches by 3.5 inches violated a statute that is more forgiving than New York's, since it says that objects shouldn't unduly interfere with the driver's view. And in New York, an appellate court has found that a traffic stop was warranted because numerous air fresheners were obstructing defendants' view of the road. Furthermore, the presence of air fresheners in a vehicle has been used to justify intrusive scrutiny of a driver because they can be used to mask the odor of marijuana. So, it may be useful, it may be awesome, but you'd better hang it where you can't see it.